The seminar on futures and derivatives law. I'm Xiajing from the International Cooperation Department of Shanghai International Energy Exchange. Glad to be your moderator today. On August the 1st this year, China's Futures and Derivatives Law, the FDL, officially came into force. As the first law in China, specifically on the futures and derivatives markets, it has attracted a lot of attention both at home and abroad. Various market participants are curious to know what this law will bring to China's futures market and how it will affect them. Actually, the drafting of the FDL started 9 years ago, back in 2013. Coincidentally, INE was also established in the same year as an international platform. The past 9 years has witnessed not only how INE listed its first internationalized futures product in China, but also the almost quadruple growth of China's futures market by trading volume and various new developments and improvements in the market. So it is fair to say that the FDL has grown hand in hand with China's futures market and complements itself as the market develops. It's not hard to find these new developments in the FDL. And today, we're very honored to have invited experts from law firms and international financial institutions to interpret this law and discuss various topics of interest. For example, what are the highlights of this law? How will it affect the market? And how does it relate to cross-border trading, etc.? Before we start, please note that the content of the speeches today only reflect the judgment of the speakers and does not represent the opinion of Sheffield or INE. All right, let's get started with the first speaker today, Mr. Stanley Zhou, partner of King & Wood Mallesons. Stanley is a partner of King & Wood Mallesons, heading its financing and financial institution group. He specializes in general banking, financial regulation and compliance, financial institutions, financial markets, and derivatives. Stanley also acts as a legal advisor to Shanghai Futures Exchange, China Clear, and other infrastructures, and is a co-author of the China Netting Opinion published by ISDA recently. As the first speaker today, Stanley will give you a general interpretation of the FDL from the opening up of China's futures market. Stanley, please.
Thank you, Ms. Xia. Let me share my slides. Hi, Ms. Xia, can you see my slides correctly?
Yes, we can see your slide, yes.
Okay, thank you, everyone. Ladies and gentlemen, it's my great pleasure to be here to speak on the futures and the derivatives law. And my name is Stanley Zhou. I'm a partner of King & Wood Mallesons. It's an international law firm headquartered in Asia and focusing on the Chinese market. And I'm happy to share my observation on the futures and the derivatives law and also its impact on the Chinese market. My speech will be divided into 4 parts. Number 1 is an overview of the legal framework of the PRC futures market. And then number 2 is generally about the history of the opening up of the PRC futures market. Number 3, impact of the FDL on the PRC market. And number 4 is other issues we think is worth noting. Okay, part 1 is an overview of the Chinese legal framework of the future market. And we can see the key Chinese regulators include CSRC and also the China Futures Association, and also the exchanges and the CFMMC. I will now speak a lot about the CSRC. I would like to mention the China Futures Association. The association is a Disseminatory Industrial Association. It is a social organization legal person, and all the futures brokers companies are the members of the association. And it also acts as a bridge between the government and the futures market, exercising self-regulation and safeguarding the legitimate interest of its members. And exchange, I will be talking about the exchange next slide, and also CFMMC. CFMMC is a non-profitable legal person established in 2006. The shareholders are the four future exchanges. Its main function is to provide monitoring and early warning mechanism for the futures margins held in futures accounts. It also is designed to detect risks and report anomalies to the Chinese regulators. And for the exchange, you can say we now have 5 exchanges conducting commodity futures, and also we have the China Financial Futures Exchange. The contracts listed on this exchange index futures and also the other financial futures. It is interesting that the legal nature of the exchanges are different. Dalian, Zhengzhou, and Shanghai Futures Exchange, they are public institutions. And the other 3 exchanges are corporations, companies. So in China, this is a little bit unique, especially about the public institution, 事业单位法人 in Mandarin. A public institution is a not-for-profit legal entity. By its nature, the income and expenditure of a public institution are dealt with on a separated basis. So it's not like a company which can distribute profits to the shareholders. And also, interestingly, public institution will not go into bankrupt or go into insolvent. So the discussion about bankruptcy risk is not applicable to Dalian, Zhengzhou, and Shanghai because they are not companies. The other key market participants include clients, the futures trading participants. It can also be divided into 2 types: ordinary trading participants and professional trading participants. And the standards for a professional trading participant will be defined by CSRC. And the other market player is the futures companies, brokers. And we also have the other future service institutions like the margin depository institutions, commercial banks, and the delivery warehouses, assets appraisal institution, accounting firms, and law firms. So the history of the laws and regulations for the futures market is like, as we know, the FDL is a very important one. And before that, we do not have a law, meaning at the state law level published by the National Congress to regulate the futures market. We only have a regulation issued by the State Council. That's the Futures Trading Regulation published in 2007. But now we have this very important law, the FDL. So that's briefly the history. And the structure of the FDL, as you can see from this chart, include general principles, and number 2, futures and derivative trading, clearing and settlement system, and the participants, Number 5 is cross-border transaction regulatory and cross-border coordination. And this chapter 12 is about the legal liability. So that's basically the structure of this law. I'd like to share the discussion about some key legal issues that may be interested for the market players. So number 1, as you can see from this slide, it's the multiple layered clearing and settlement mechanism as provided by FDL, which have also been long-standing before the issuance of the new law. So that's basically the structure and the settlement system of the Chinese futures market. There are 3 layers. If you look at the structure, the chart, each lower level will deposit margins and conduct clearings with the upper level. So the relationship between traders and futures companies is like the broker or agent-client relationship. So there are some discussions on the clearing model, like is it an agency model or it's a principal-to-principal model? I think we will be discussing this issue at a later stage at the panel. And you can see there are futures companies and also clearing and settlement participants from this chart. At the right side, it's the clearing system adopted by the China Financial Futures Exchange. So it's for financial futures. And on the left side, it's a clearing structure adopted by the other commodities exchanges. The key difference between these two systems is that you can say there is a type of trading members and also the so-called general clearing members on the right side. So that's unique for the financial futures. The trading members are normally those small futures companies which are not qualified as the general clearing member of the financial exchange. Okay. The next legal issue or the key feature of this market is the daily mark-to-market clearing and settlement. And also it is linked to the clearing finality issue. The daily mark-to-market means that the futures clearing and settlement institution will clear all contracts of the clearing and settlement participants after the close of each trading day at the clearing and settlement price, including profits and losses and tax and fees, with a net transfer of all amount due and payable. For clearing and settlement participants with insufficient margin, they will be notified to make additional margin calls within a specified time limit, following which the risk control measure, including forced closeout of positions or default disposal mechanism, will be implemented. So the daily mark-to-market system inherently contains a risk controlling function, controlling the exposure at default within the net of the daily profit or loss. And the finality of clearing and settlement outcome is therefore of importance to all the parties in this clearing and settlement chain. And now the law recognizes the finality, clearing and settlement finality. The legal recognition of the clearing and settlement finality is reflected in 2 main points. Number 1 is the result of a transaction cannot be modified, cannot be changed. So Article 26 of the FDL makes it clear that the result of a future transaction is definitive unless there are exceptional circumstances, such as a sudden event causing a material trouble in the result of a future transaction. That's set out in Article 89. The issue has not been changed significantly before and after the introduction of FDL. And the number two on finality is the impact of insolvency or bankruptcy. Now, before the new FDL, the legal basis for the finality of futures transaction is Article 27 and 29 of the regulation, as I just mentioned. And now we have the law, and the law confirmed that the finality of the futures transactions cannot be changed. And also it includes the involvement of all the parties involved in the transaction, including exchange and the clearing institution as a CCP. Next feature is about the treatment of margin. So the law provides that the amounts such as margin and options premium will be segregated from the other funds and will be deposited in a margin depository institution. This is to avoid misappropriation of such funds. So this is about the feature of margin. So there can be some discussion about the legal nature of the margin, and the key point is like in the insolvency circumstance, who will be the owner of the margin, and will the margin be treated as bankruptcy remote from the bankruptcy or insolvency risk of the commercial banks who are acting as the depository institution. We think that the new law, though it is not 100% clear, it provides that the margin will be firstly will be used for settlement. So though the law is not very clear that margin is bankruptcy remote, but we tend to view that it will be protected from the insolvency of the depository banks. Next is about the enforcement and portability of collateral. That's also a key attribute requirements in the international standards, and the law now adopts the relevant principle. So we think this is also a development of the new law to achieve international acceptable standards. And other key legal issues, including single agreement and close-out netting and title transfer as a type of collateral. These elements are more important for OTC derivatives. As you can see, these are the key elements required by like ISTA, and recently we have assisted ISTA to publish the legal opinion to recognize China as the netting jurisdiction. So I think that this is a great development for the OTC derivative area. and we can discuss all these issues at a later stage at the panel. Okay, so let's go to part 2. In part 2, I just want to share with you some overview of the history of the opening up of the Chinese futures market. As you can see, I think the development of the legislation is a long ways and is to support the opening up of the whole market. As early as 2006, we have the first Chinese foreign joint venture futures company. And then in 2011, QFII is allowed to participate in the futures market, but it's only in the index futures. So it can only trade on the China Futures Exchange, Financial Futures Exchange. And significant development is in 2015, the introduction of foreign trading participants and foreign brokerage institutions to participate in some specified types of futures contracts. Following that, the Shanghai Futures Exchange set up the INE and allows foreign traders to trade some of the products on this platform. So foreign investors will be interested in the routes and channels for them to accessing the PRC futures market. We can see there are major 3 routes. Number 1 is QFII, but QFII will need to have qualification approved by CSRC to act and qualified as a QFII. And it also needs to trade through an onshore broker. But the upside is that they can accessing a wider range of the contracts, futures contracts. Second one is the direct access model. But the downside for this is that they can only access to certain the so-called internationalized contracts. So limited types of futures contract under the second channel. And the third one is to set up a wholly foreign-owned broker in China. That will need to be approved by CSRC and get a broker's license from CSRC. And it is worth noting that the futures companies cannot do proprietary trading, but they can set up a risk management subsidiary to access to a broader scope of business. The opening up also includes quite a number of cross-border collaboration between onshore and offshore financial infrastructures. As you can see from these 2 slides, the Shanghai Gold Exchange and the Financial Futures Exchange, the Shanghai the INE and other Chinese exchanges, they have been in discussion with overseas exchanges, and there are some types of cooperation, including order routes and also share of the information, and also they can do so-called connect, different types of connect between onshore and offshore infrastructures to provide a wider channels for the international and overseas participants to join in and make investment in the onshore market. And there are some unique features of the Chinese market. The first one is the hedging. It is a regulatory requirement at the very first beginning. It is required that the tradings will need to be on hedging purpose. And also, there are some regulations that require the state-owned enterprise and state entities and state-controlled enterprise in China to do futures and financial derivatives only on hedging purpose. And also for QFI, the derivatives tradings by QFI, CIBMs, and Bond Connect, they are also required to do the transactions for the purpose of hedging their foreign exchange risk. Another unique feature is about the existence of CFMMC, the China Futures Market Monitoring Center. Its function is to monitor the entire futures market, and it has the ability to access to the data and information from all the settlement banks, which is not possible, I understand, in some foreign jurisdictions. So this enables CFMMC to have quite a lot of information to support its function to monitor the whole market. And also it provides a uniform account opening system in the futures market, which relates to the next slide, the look-through regulatory approach. It includes three elements. Number one is the client real name requirement. First, the clients now we say traders or participants of the futures companies, they must open an account with their genuine identity. And in the meantime, the market monitoring center will verify the client's personal information with the relevant authority to ensure the authenticity of the account holder's personal information. The second one is the so-called one account, one code system. One account, one code system means that a client can only obtain one investor code in one exchange. A client can only acquire one trading code in one exchange, regardless of how many futures companies are used by the client as brokers to open their account. And the client codes are exclusive and may not be borrowed or mixed during the transactions. If future markets in other like US or other developed countries generally adopt a mixed code trading, whereas exchange only have access to the trading activities at the member level, but not look through to the trading activities of each client. So that's quite different between China and other countries. And thirdly, it is a trading activity monitoring and surveillance system built on the basis of the two aforesaid system. Exchanges and the futures market monitoring centers, they can observe, track, and analyze futures market risk based on their monitoring data. Another unique feature in the Chinese market is about the mandatory closeout system. The mandatory closeout means that the futures exchange will have the power to force its traders to close out the position in certain circumstance. For example, if the balance of the margin is negative and is not paid up in a certain required period of time, or if the trader's position exceeds its position limit set out in the relevant trading rules, or if the certain contract is facing some extremely market condition. In these circumstances, the exchanges will have the right and power to force the traders to close out as positions. Another one I would like to draw attention is about the insider trading regulation. The insider trading or insider dealing, as you know, is widely accepted in securities market and securities trading market, but it's not so much in futures trading, because the reason I think is like insider information would require logically, there is some information that should be mandatorily disclosed to the public at maybe at a later stage. And now some traders hold the insider information and leverage this information to do the trading on the market and make a profit. The FDL have a clear provision and a definition about the insider information, and also persons with knowledge of insider information. And the provision is that all those persons are not allowed to do trading or leverage the insider information obtained or owned by them to make profit. But this, I think, is slightly different from the regulations or laws in some other jurisdictions. Like, for example, I understand in the US, there is no such requirement or similar stricter requirement, because they don't think they have, for example, in the securities market, issuer or other related parties who have the relevant information disclosure obligation. And in the futures trading market, people believe that some market players, they have their unique information, and they know their own position and other information, and they can use this information to do trading to make profit. I think this is a complicated issue, but I just want to draw attention to the especially international traders, that the requirements under the Chinese futures and derivatives law may be different from those in other jurisdictions. So it's a unique system. Okay, let's go to part 3. That's the impact of the FDL on the Chinese futures market. You can see the direct impact on the business of futures company. It includes the potential expansion of the scope of business of futures company. That's Article 63. This clause provides that futures companies can do other futures business activities, and it does not expressly prohibit proprietary trading by the futures companies. So it leaves room for the market to imagine that maybe in the future, futures companies will be allowed to do properly trading. And the other point is about the burden of proof. It resides with the futures business institution that's with the futures companies. So it sets higher requirements for the retention of evidence in the course of daily business. Another point is about stocks, shares, and stakes in investment fund or bonds can be used as margin. So not only cash can be used as margin. The recent development is that state-issued bonds and maybe in the future, the stocks and other securities can also be used as margin for futures trading. The new law also provides for the separation of clearing and settlement participants. Under the new law, we will have the clearing and settlement participants, and also we have the clearing and settlement institution. And about the finality, I think I discussed about the finality at my early slide. Okay. Last part is about other issues to be noted. To be noted by the foreign companies who will have interest in setting up futures companies in China is about the investor or trader suitability or eligibility issue. The FDL provides very strict requirements on the KYC. So futures companies, when providing service to its client, it will have the obligation to fully understand of the basic information and the financial condition and the other financial portfolio and trading knowledge of the client. And if the fail to do that, and it causes loss to the traders or their customers and clients, it may face the liability to compensate the loss of the traders. And there are a couple of case precedents in the market. Some futures companies have been also penalized by the central bank for failing to do so. Okay, given the time constraint, it's just a very quick overview of the new futures and derivatives law. And thank you. And I'm happy to have this opportunity. And I'm happy to discuss the other questions at our panel stage. Thank you.
Okay, thank you. Thank you very much, Stanley, for the comprehensive interpretation on the FDL.
Thank you. I stopped the sharing screen.
Yeah, thank you again very much. And just now, Stanley just gave us a very comprehensive interpretation on the FDL. And as you can see from the regulatory framework and key legal issues, and to the opening up process and unique features of China's futures market, Stanley just gave us a whole picture of China's futures market, which we believe will be helpful for us to better understand the FDL and the market that it regulates. And next, we will move on to the second part today, which is a panel discussion. The moderator will be my colleague, Mrs. Yiping, Associate Director of the International Cooperation Department of INE. And the panelists consist of lawyers from domestic and international law firms, and compliance chiefs from overseas financial institutions. Next, I will pass the mic to Yiping to introduce the panelists and kickstart the panel. Yiping, please.
Okay, thanks, Xiaojing, for the introduction. So now let's move on to the panel discussion part. Please allow me to first introduce our great panelists today. The first, of course, is Mr. Stanley Zhou, whose expertise and charm has been clearly demonstrated in the previous session. Our second panelist, Kimi Liu, is the counsel in the Financial Regulation Department of Shanghai Heping Law Firm. He has extensive experience in financial regulation and regulatory investigations, derivatives, cross-market businesses, and so on. Prior to joining Heping Law Firm, Mr. Liu worked at a leading international law firm for nearly 10 years. He also worked at Morgan Stanley between 2015 and 2016 as head of legal department, board counsel of Morgan Stanley International Bank China Limited. Next one is Ying Zhou. She is a key member in the structured finance and derivatives team, is based in latest joint operation with Zhao Shen in Shanghai. She has extensive experience in derivatives and structured products businesses, in the foreign exchange market, interbank bond market, the stock market, and the futures market. And she is also highly familiar with issuing transactions and regulatory opinions on financial markets in China. She has worked closely with a number of domestic and foreign exchanges and clearing houses for almost 10 years. And also we have Ling Zhang. She is a chief risk officer of JP Morgan Futures. She is an expert in the futures industry with rich working experience in law firms, exchange, regulator, and futures companies. She was deeply involved in the design and practice of opening up China's futures market, drafted trading rules, and contributed to the development of the industry. She was granted great honors, such as the National Financial Women's Model and Shanghai Young Talents. The last one, and also the important one, Attilio Ferrari. He is executive director and senior legal counsel of Goldman Sachs. He joined Goldman Sachs in 2007, and in that time, he has worked in a number of legal counsel roles across Europe and Asia. He is currently based in Goldman Sachs Sydney office, covering global markets business areas in the APAC region, including prime brokerage and futures. Okay, so much for the introduction of our distinguished panelists. Welcome to you all. And I see that most of you, all of us have the cameras on. Okay. So today's discussion will mainly focus on three aspects, which are the futures market, OTC market, and cross-border businesses. So some of the points have been mentioned in the previous presentation by Stanley, but it's still worth listening to the other panelists for their opinion and comments. So before we start, I would like to ask our panelists, what is the significance of the futures and derivatives law? Why is it set a historic development, and how would FDL make a difference to the market? So Attilio, do you see that the futures brokers and clients, do they have much comments, and what do they feel about the FDL in China?
Thanks, Yiping, and firstly, thank you to the INE for organising this webinar and for inviting us to participate in the panel discussion. So the FDL is a momentous piece of legislation. For the first time, we have a comprehensive legal and regulatory framework for exchange-traded futures market and for the OTC derivatives market in China. For the first time, we have at national legislation level we have expressed recognition for the enforceability of closeout netting provisions and the single agreement concept that is commonly used in OTC derivatives documentation. So as a result of the FDL, PRC will become what we refer to as a clean netting jurisdiction, and the previous legal uncertainty as far as dealing derivatives with PRC counterparties hopefully is dispelled. So it's an important step forward for China's derivative markets. Closeout netting is the single most important mechanism for the reduction of credit risks that are associated with trading derivative contracts, and netting enforceability is an indispensable foundation for safe and efficient derivatives markets. And having a derivatives market that is robust and safe and efficient, that can positively contribute to economic policy. Derivatives enhance the ability of market participants to manage risks and thus improve the efficiency and safety of capital markets. And that in turn helps channel capital into productive sectors of the economy. The use of derivative products to manage market, credit, FX and interest rate risks not only enhances the ability of domestic companies and investors to manage risks, but it also increases the attractiveness of foreign investors to participate in the local markets in China.
Okay, and what about Stanley? As a lawyer, do you see any or many requests from overseas clients? What are the main questions and feedbacks they have for the FDL?
Thank you, Yiping. Yes, of course, we have received quite a lot of questions and queries from our clients, in particular overseas clients. I think they are quite exciting about the new FDL, and our clients in asking questions include some large commodity traders, some hedge funds, and also international financial institutions like investment banks, and also from some overseas exchanges. I think they are interested in questions like, number one, the routes or the channels for them to join in or participate in the Chinese futures market in the future. What are the channels, and what are the pros and cons? What will be the time frame for them to get license, and how can they get into the Chinese market? That's the number one question. And then number two is the impact of the new law on their current business model. For some overseas exchanges, they have the consulting office in China. They have representative office in China. They are doing some branding and cross-border marketing. So what will be the impact after the new law? Do they need to get some license, or if there are some requirements or filing requirements, or do's and don'ts that they can do and cannot do, and also for futures companies, brokers, and traders, they are also interested in the impact on their current business model. And number three, I think, is about the risks. They also asked about what are the risks for them to join in the Chinese market, and in particular, what are the additional risk that they are not familiar with, because all these market players, I think they are professional players. They have experience in the foreign jurisdictions, like in the Europe and in the US. But now they are coming into a new market, and there is a new law. So what will be the additional risk? And especially what will be the compliance risk. As I mentioned in my presentation, for example, in insider trading, the regulatory regime is quite different between the Chinese legal framework and overseas markets. So what they can do and cannot do, they need to watch out all this risk. So they are quite their risk control departments quite interested in this. For all these questions, I would say we provide some advice, but we still need to watch out for keep an eye on the development of the legal framework, because the law is new and there will be more and more implementary detailed rules and regulations to be published by the government and by the regulator like CSRC. So we need to keep an eye on this and carefully and make an analysis on the risk associated. And on that basis, our international clients will form their strategy and their route to go to the Chinese futures market. Yiping.
Yes, I think that's true for almost all the participants in the futures market going forward, and to look out for new developments and other issues or other introduction of the rules and regulations. So now we would like to discuss the futures market. Many of the common practice in China's futures market are written in FDL in the form of law. So we see that includes margining, position limit, forced position liquidation, etc. So when dealing with foreign investors, which are the Chinese rules that they find most different from overseas practices? I think that that goes to the two panelists from the futures brokers. So what is your understanding of such rules, including their advantages and disadvantages, and why are they suitable for markets like China? Attilio, you want to go first?
Sure. So Stanley in his presentation listed out some of the main differences between the futures market in China and other jurisdictions. So I won't go into a lot of detail around that. I guess for foreign investors, the main, most of the questions that we get and that the questions that foreign investors have are around, sort of the pre-margining requirement, and also the rights that brokers have to close out on certain events. So when it comes to looking at brokerage agreements and so on, most of the questions from foreign investors are around those issues. One good thing that the FDL does, and I think it's in Articles 41 and 42, is that it gives a clearer legal basis for things like mandatory closeout. So that's a positive thing, and I think it gives a bit more certainty and clarity to foreign investors about how those requirements work in China.
Okay, what about Ling, also from broker? Do you have anything to add?
Yeah, thanks, Yiping. It's honored to be here to express my views here. And I would say there's another sense like a way to celebrate the effectiveness of the futures and the derivatives law. By speaking so, I'd like to say all opinions I express here are the personal views here and not those of JP Morgan. So besides the pre-margin, and I think there is one mechanism I'd like to highlight, and we'll discuss a lot with offshore participants here. That is the real name system. That's quite different with the offshore markets. In the Chinese market, each end client need to open an account with its real name. And the participants will need to apply all these trading materials and with the brokers in the CFMMC trading code system. And the CFMC will deliver these trading application materials to the relevant exchange, and the exchange will recheck and assign a unique trading code to the client. I'd like to share some of my understandings about this unique trading code system. And I think this is quite, this can be the foundation of the risk control system in China, in where the trading limits, position limits, all based on the unique trading ID mechanism. So I think when we all understand that this kind of system is quite critical, and we also understand that why the regulators need to ask the client to report the active control relationships, because when all these combine together, the regulators can implement the look-through system and have a whole picture of this. But from the client side, I think the clients will always worry about how about my positions, exposure. And in this situation, I think the Chinese market develops quite a lot, and the exchanges revise the information disclosure mechanism, and only when the market, when the amount goes to a certain amount, and the brokers will have the obligation to disclose the positions, but not the clients. So I think there is always a way to balance the regulators' requirement and the clients' needs, business needs here, and we see quite a development here. And I think more and more products in China's market open to the international market, and the global participants get in. They can have a deep understanding about the Chinese rules. And with that, I think we believe the market rules will ultimately be a common choice for the to facilitate the development of Chinese market. Yiping.
Okay, thank you. So regarding futures trading, clearing, market surveillance, delivery, etc., are there any points in FDL worth highlighting to market participants? I know that Stanley have mentioned a few. How would these articles make a difference to them? So Kimi, would you like to answer this question?
Yes, sure. Thanks, Yiping. I think maybe I can start with one point. The FDL provides for waterfall to determine how the financial resources shall be applied to address the default situation. That is Article 42. So basically, it provides for the details as to how to deal with the broker's default, as well as the broker's client's default. So these provisions are quite important because previously, actually, before the FDL took effect, we worked with several clients on this issue, and there was a concern that any default happening at the side of other brokers may affect the non-defaulting brokers kind of asset security. And at the same time, any trading participant may also have the concern that its brokers default, as well as other clients of the broker's default, may also contaminate the trades that it placed in the market through the broker. And this Article 42 is quite important, that it provides for clear risk segregation mechanism through a clear waterfall. So this definitely will enhance the confidence for trading participants and will help attract more investors into this market.
Yes, thank you. So anyone have anything to add? Ying, please.
Thank you. I think from clearing perspective, the protection of close-out netting, settlement finality under the FDL, this would no doubt give the market participants greater confidence in joining this market, apart from the waterfall point that Kimi just mentioned. There are also certain trading features unique to the China futures market that I was mentioning. And these features have been there before, even before the FDL, and haven't been substantially changed by the FDL, but may be a bit new to offshore investors who just come into this market. So just name a few for as an example, such as the real name account system CSU principle that both Stanley and Ning just mentioned about, the no off exchange trading rules, the forced trading rules, and the filing of actual controlling relationship. I think in previous speakers' talks, they have covered most of these points earlier on, but we won't repeat those points, but just to briefly mention two features probably that haven't been covered in detail earlier on. So first feature for China futures market for trading that I want to talk about here is the no off exchange trading rule. This is very similar to the rules in the China stock market and bond markets that people probably would be familiar with if you have used Stock Connect or Bond Connect before. This means that you cannot transfer your futures contract to another person other than through the centralized trading system of a futures exchange. Or pursuant to very limited exemptions under China law. And the second trading features is the founding of actual controlling relationship. Ning also mentioned briefly for the purpose of the see-through principle, but from the position limited perspective, it probably have other implications as well. So this is very similar to the acting in concert concept in the equity market. So for position limit purpose, positions of persons that have actual controlling relationship with each other need to be aggregated for calculation. Unlike the acting in concert concept in the equity market, if you do have actual controlling relationship with each other and you both trading in this futures market, you actually need to make an upfront filing with the exchange. And this relationship can arise not solely because of the equity controlling relationship between each other. It can also due to some contractual arrangement. So if, for example, in some OTC derivatives contracts where people may have an obligation to hedge in a certain way or dispose their position in a certain way, you might also need to be aware of this point. Thank you.
Okay, thank you. I actually have another question for you. It is said in the FDL that CCP clears with its clearing members, and the clearing members in turn clears for their clients. So to your understanding, is it more like the principal model adopted by Europe or agency model adopted by US? And what does it mean to the overseas investors?
Sure. Probably just a brief explanation of these two models. So these are the two client clearing models in the EU and the US for clearing of futures and OTC derivatives. So i.e. principal model and agency model, as you just mentioned. Under both models, actually the clearing participant is liable as a principal when they face the CCP. And one of the key differences here between these two models probably is whether there is any back-to-back transactions between the clearing participant and its clients. So neither principal model nor agency model is a traditional China law concept, and whether it is indeed principal model or agency model depends on who is asking this question and what's the rules in their local law. And when they answer this question, of course, they need to take into account the rules and operations in the China market. These are not very straightforward concepts, and that have very well-defined scope and meanings. And in particular, the interpretation and the approach in the US in relation to whether it's agency model, principal model, have evolved quite a bit in the last few years as well. So it is probably not surprising that China model probably does not fit perfectly into either of these two models. And it is true that FDL itself is silent on this point as well. But looking at the clearing rules and procedures of most of the futures exchanges in China, one point that is quite clear to us is that there is indeed no back-to-back transaction between a clearing participant and its client. So on that basis, it does appear to us that the client clearing model in China is probably more akin to the agency model instead of the principal model. Of course, when you need to make the actual determination, you will always need to examine the rules and of the relevant exchanges in greater detail and make such evaluation on a case-by-case basis. Thank you.
Okay, thank you. It is said that in the FDL, it pays great emphasis to risk management and fair trading. So, Kimi, do you agree with that statement? How is it illustrated in the law? Which are the illegal activities mentioned in FDL and what could be the penalties? Would you like to mention some points?
Yes, sure. Thanks, Yiping. I think Stanley already mentioned in his presentation that there are quite comprehensive rules on insider dealing, on market manipulation, and on the kind of dissemination of false information to other market participants. And indeed, all of these misconducts are kind of prohibited or restricted by the FDL. And from a legal perspective, actually, I want to highlight one more issue. It's quite subtle, but important. That is the kind of scope of insider dealing and market manipulation in the futures market is different from the securities market. I think people may know that a lot of trading participants in the futures market themselves are actually the kind of source of demand or supply. They either produce a lot of those commodities or they need to consume a lot of such commodities. So actually, as you know, the price of the market will be determined by the supply and demand. And those participants themselves, based on their own situation, then will have a determined force to kind of affect the market price. And on this basis, I think it is quite natural for those market participants to control their costs in order to make a successful business. So there could be some kind of conflicts for their trading behavior. On one hand, their trades will definitely affect the price, but on the other hand, they have fundamental interest to control their own costs or maybe maximize their own profits, and which seems not illegitimate in this context. So I think also the law have the kind of basic rules for insider dealing, for market manipulation, but still I think further enforcement and guidance need to be formulated in terms of how to determine, in particular, those kind of market participants holding physical position, as I explained, how to kind of define the kind of scope that they may leverage their position to trade. And I think generally speaking, there should be certain tolerance for such trading activities because which supports the real economy. But on the other hand, the protection of interests of other trading participants shall be paid attention to, because then their kind of benefits may also be affected by those large participants in the market. Given the FDL is relatively new and there's a kind of quite short enforcement record on these provisions, as you mentioned. So it is still something that we need to observe and we need to work together to make sure that the market will travel in the right direction. Thanks, Yiping.
Yes, thank you, Kimi. What about Attilio? Do you have anything to mention to your clients?
Well, I agree with Kimmy. I guess one thing I'd say from the perspective of outside of China is that I think a lot of the focus on the FDL outside of China has been on the netting aspects, because that's particularly important to institutions outside of China. But the FDL is actually a very comprehensive law, and it covers much more than just netting. So something like the insider trading and the market manipulation articles that Stanley and Kimmy were talking about, I think investors coming into China will need to focus closely on those as well.
Okay. Thank you, Attilio. So we will move on to the brokers. So futures companies can carry out not only brokerage business, but also consulting, market making, etc. Stanley also touched upon that. So Ling, do you see any new opportunities implied by this clause? How do you expect this would change the business goal or company scale or profitability of China's futures firms?
Thank you, Yiping. Yeah, actually, Article 63, I think, of the FDL defines the business scope of the futures company. Compared with the administrative regulations of the futures trading, there is a significant change which deletes the restriction. Futures companies shall not engage in proprietary business. And just now, Stanley also mentioned that there might be an opportunity for the futures company to engage in the new business. But I would like to say it might be too early to say that the futures companies are able to do so. But at least there is no such legal restrictions now. The more compliant a futures company operates, the more likely it will be able to launch new business. Meanwhile, we also noticed that qualified securities companies are entitled to carry out this housing business, and they also have explored risk control measures here. So besides talking about the market making business, it has been added in the business scope. But at present, usually we see the RMS, the risk management subsidiaries of futures companies are engaged in the market to do the market making business. But I think if the futures company can choose how to engage in this kind of business, whether by itself or by its subsidiaries, that will provide much more flexibilities, and the futures companies can have choices and decisions when and how to get into the market, like that, to engage in this business. So I think for their right now, it is undoubtedly their business scope in the FDL has expanded, but we also would like to highlight a little more about the outbound business. We saw the it is stated in the administrative regulations, but there's rare writing up about the how to do the outbound business, but we saw a lot more information here in the FDL. So that is a kind of new business can be implemented, but we are looking for the detailed rules.
Okay, thank you, Ling. Anyways, we do see quite a bit of potentials going forward. So let's wait and see how it develops. So besides the futures companies, let's look at exchanges as well. We noticed that some new development in FDL regarding exchanges, including the separation of two concepts, exchange and clearing institutions. And also we see the listing of new products requires filing now instead of getting approval from CSRC. So Ling, what is your understanding of these clauses?
First of all, I would like to say this separation is very forward-looking and more consistent with the international market. FDL provides a special chapter on the futures clearing institutions, the clearing house. From legal point of view, the separation of exchanges and the clearing houses would makes the legal concepts, the rights and obligations pretty clear. And from practical point of view, this does not mean that the Chinese futures exchanges will be immediately divided into the exchanges and or the clearing houses. I think the current model is compliant with the law as well. One legal entity holding two licenses. Further, and it is also provide the legal support if the separation model is expected to be adopted in the future. For the new product listing mechanism, I think it is similar in some respects to the IPO registration system in the securities market. This should be a long-waited system, but which we do not expect it can be carried out so soon. We understand that one futures product is closely related to an industry, and adequate communications with the industry and all the stakeholders can facilitate the future, assistance the further development of the market. Recently, CSRC approved GCE to list the rapeseed oil and peanuts options on 26 August, which are the number 1,100 and 101, the products in China's market. But however, there are only 9 products open to the international market. So I think there's a quite a development here, and we expect more and more products listed in the market, and also more and more products available to global participants. Thank
Okay,
you.
we have the same wish actually. Stanley, do you agree with Ling?
Yes, I agree with Ling. As for the new system about filing instead of getting approval, I agree with Ling that we still have a long way to go, because in China, I would say filing sometimes just like or similar to approval, and also because the market in China is not so mature as foreign markets. So we still need the regulator to act as a watchdog. So yeah, basically I agree with that. But I think we have this expectation that we still need to wait.
Okay. Okay, so much for the futures part. Let's move on to the derivatives market, which actually drew quite a lot of attention from domestic and overseas clients. So for the derivatives part, though for our exchange, we engage mainly in the futures business or exchange traded business. So is it relevant? Is the derivatives part, which mainly focus on the OTC trading, relevant to our exchange? Stanley, what do you think about that?
Oh, of course, I think they're relevant. We have many banks clients and other clients like the futures companies risk management subsidiary. They are offering products, OTC products to their clients, and this is on one side, and the other side they will do hedging on the exchange to hedge their own risk. So, for example, the OTC products offered by banks and other institutions to their client, the pricing and the tenor and the other features of the product will be linked to those contracts listed on the futures exchange. So I think they have a very close connection between each other. I think the new law, the new FDL, it recognizes quite a number of international attributes that is required for the OTC derivatives, and also for also equally applicable to the financial infrastructures. So I think the alignment of the standards between each other will be good for a more closer connection between the OTC derivative markets and the on-exchange markets.
Yes, I also agree with you. And well, FDL recognizes the single agreement concept that Stanley also mentioned. Ying, what do you think that means, and why is that important? What's your understanding of this clause?
Sure, thank you, Yiping. It is a great news to the market that Article 13.2 of the FDL now expressly recognize single agreement concept. This is in addition to the recognition of close-out netting arrangement, and would by itself further strengthen the close-out netting arrangement. So first of all, recognition of single agreement would effectively prevent the administrator of a defaulting party from cherry-picking individual transactions based on Article 18 of the PRC bankruptcy law, and also protects defaulting parties' right to close out. It also means that PRC courts would more likely to respect a single net amount owing by one party to the other under this single agreement, so that to protect non-defaulting parties' right to net. So for the purpose of achieving netting, it probably is no longer strictly necessary to rely on the bankruptcy settle provision under Article 40 of the PRC bankruptcy law, so which impose some additional requirements in order for set-off to be recognized. Thank you.
Okay, thank you. Attilio, what's your understanding? Do you agree?
I agree. Single agreement is a really important concept for netting enforceability. The good thing about the FDL is that it specifically mentions that concept in a way that is very similar to close-out netting laws in major jurisdictions outside of China. So that means that foreign investors and foreign institutions are reassured by having the single agreement concept in there. So I think it's really important and a really positive development that the FDL makes reference to it specifically.
Yes, and so as we have mentioned several times about the close-out netting, what exactly does it mean? Is it widely adopted by global financial markets, and why? How would it impact the cost of doing derivatives business with or without close-out netting? Kimi, would you like to share your opinion on that?
Yeah, sure. Thanks, Yiping. And I think Attilio has mentioned the significance of single agreement. Actually, close-out netting is based on single agreement. I think in short, based on the single agreement, i.e. all the trades and the corresponding legal documentation will constitute a single legal instrument for derivative trading. On this basis, people agree that upon certain events, I think people mainly deal with event of defaults just arising from those bankruptcy events. Upon such event, the non-defaulting party can early terminate all the transactions and settle with its counterparty on a net basis. This is a quite important legal technique to help derivatives trading in entities to control their counterparty's credit risk, because if no netting, then this means that the counterparty need to settle with the other on a gross basis, i.e. to just add all the trades and then pay to each other. And under the bankruptcy law, because all the assets need to be collected by the administrator and all the debts need to be kind of filed and participate in the distribution of the assets, which is a significant credit risk for those institutions participating in derivatives trading. And after like almost 2 decades work, China finally has obtained the netting jurisdiction status. And I know that ISTA has already just issued the netting opinion for China. And this is the work product of many market participants. And finally, we are here. As you mentioned, this may have some costs for trading derivatives with China counterparties. As I mentioned, this linked to the credit risk. And based on the current capital rules in many countries and regions, generally speaking, the higher credit risk, the higher regulatory capital an institution need to put aside. If people can treat trades with Chinese counterparty on a net basis, this means that they can put aside less regulatory capital for those trades. And this will definitely lower the costs for such trade. And it is expected that when people just finish their internal work to turn on netting for trading with Chinese counterparties, they will be able to offer more competitive price compared with the previous kind of trades. And this is definitely something positive for the China market. And I think there might also be other issues that may follow, like the regulatory margining requirement, like the treatment of various other financial market transactions, and still a lot of work for lawyers, for other market participants to work together to tackle. Thank you, Yiping.
Thank you, Kimi. Cross-border business is another important section that is widely discussed in FDL. What are the relevant requirements on overseas exchanges when they come into China for business relating to futures and derivatives, Kimi?
Yeah, sure. I think there are 3 main requirements. Then, first of all, when it just offer direct market access to Chinese market participants, it will need to kind of obtain the registration with CSRC. Secondly, when an offshore exchange issues those lookalike contracts, i.e. those contracts which will be settled based on the settlement price of domestic futures transactions, this will need to follow the rules to be issued by CSRC. And thirdly, if they want to carry out those marketing activities in China, they will need to get the approval of CSRC as well. But under the current regime, which has already been confirmed by the FDL, if they want to set up a representative office in China, this is permitted so long as they can obtain the approval of CSRC. But note that the representative office can only do some liaison and logistical work rather than any marketing activities. But still, this can help their kind of education and some general relationship and market kind of promotion activities in China. So I believe these are the most relevant rules for offshore exchange for doing some business in China.
Okay, thank you, Kimi. Besides the overseas exchanges, let's also look at the overseas brokers and investors. What could be the consideration for overseas brokers and overseas investors when entering into China?
Sure. So when they enter into China, issues regarding, for example, close-on netting, finality, client clearing model, protection of margin, etc., are no doubt very important considerations for these offshore brokers as well as investors. Given these have been discussed extensively by other speakers, we will not repeat them here. 2 points I would like to highlight here are firstly the cross-border licensing regime and also the cross-border data transfer. So FDL probably is the first law in China that sets out a cross-border licensing regime. So making such licensing regime open to overseas brokers can make it possible for them to carry out certain marketing activities in China, and also make it easier for them to accept China onshore investors to become their clients for trading offshore. That being said, although FDL has come into effect, details of the licensing requirement are expected to set out in the implementing rules only, and these implementing rules have not come out yet. So details such as how to apply for a license and whether there are any exemptions available are not clear to the market yet. So during this transition period, it is quite important for overseas brokers to be aware of the requirements that have already come into effect, and not to carry out regulated activities before they actually can obtain relevant consent or license in China. The other point is the cross-border data transfer. This is not unique to the futures or the OTC derivatives market, and nowadays probably this has become an issue that everyone has to bear in mind when carrying out any cross-border activities. So on restriction of cross-border data transfer, the good news is that the final version of the FDL is actually less stringent than the draft version published earlier on. In the final version, the approval requirement only catches data provided to offshore regulators instead of all the futures related information. However, for data transferred to, for example, your offshore parent or auditor, with a view that this will be likely to be submitted to regulators of the offshore parent or auditors, this you might need to be particularly careful whether this might also be caught by the restrictions on cross-border data transfer. Thank you.
Okay, thank you, Ying. What about Attilio? What do you think are the points worth highlighting to overseas brokers and investors?
Look, I agree with Ying. I think the two things I think that foreign brokers and investors are going to be very interested in is firstly seeing the detail around the cross-border marketing and licensing. Hopefully the regulations that come out provide some clarity and some certainty around how that's going to work. And the second thing, as Ying mentioned, is the data transfer provisions. So the final provisions in the FDL, I think, were better than what was in the original draft, less stringent. So I think that was welcomed by foreign brokers and investors. But I think for foreign firms looking to come into China cross-border, understanding the way, the restrictions around data transfer and the way those rules work is going to be a very important aspect. And I think the other thing is, I think foreign investors and brokers, there's a number of channels that are available to them now to access the exchanges in China. The overseas intermediary channel, we think, has been a very effective channel for foreign investors to particularly, to access the commodities futures markets. That's been very popular. So I think increasing the optionality and the number of avenues that are open to foreign brokers and investors, hopefully that continues.
Okay, thank you, Attilio. Now let's move on to look at the other way around. For the domestic institutions and investors looking to trade overseas, is there any points worth mentioning in the FDL? Kimi, would you like to answer that?
Yes, sure. Thanks, Yiping. I think there's a rule that is relevant for this question. That is Article 120. It is provided that domestic institutions and investors who want to trade offshore futures, then will need to engage an onshore broker, which is licensed to provide such international business. However, I understand that this business is still not available in the market. Also, there are some kind of pilot programs launched by CSRC in early years, but under the FDL, this regime is still not kind of implemented at this moment. And one thing I can further mention that this is the domestic requirement. When you look at the international markets, I think speakers on this panel already alluded to some extent that there are two models. One is principal to principal, the other one is agency model. Then how the onshore broker's role can be fitted into either the principal to principal or the agency model is still something people will need to work out. The current FDL only have several generic provisions as to those cross-border futures trading, but in reality, given different jurisdictions, different markets may have quite different rules in terms of granting access to international participants. I believe that there will be a lot of work to be done and a lot of kind of procedures need to be set up for PRC institutions and investors to trade offshore futures. So still quite a lot of work to do, and definitely we are happy to explore this together with any institution or investor of interest.
Okay, thank you, Kimi. Ling, what's your understanding on this question? Do you have anything to add?
Yeah, I totally agree with Kimi, and I think there are multiple ways to access the overseas market, but overall, anyone need to go to the markets from onshore, need to comply with both onshore regulations and offshore regulations here. And further, there is one more point I'd like to raise out, that is when we all realize that the data cross-border transfer is quite keen for all these cross-border business, and we also urgent and looking forward for the regulators when they are making rules, mean to define important data and to make detailed restrictions. We expected them to consider the business needs and the BAO data cross-border, and that is what asked from our industry, I think. Thank you, Ping.
Okay, thank you, Ling. The next question is also for you. FDL recognizes the CCP status of domestic exchanges. So how would that impact the global brokerage business, like the business that you are in?
Futures clearing institutions as the CCP conduct unified clearing to provide centralized performance guidance for futures trading, effectively reduce the credit risk of the counterparty, along with the potential systematic risk arising from the default, which have been always adopted in China. And I think the CCP status and net settlement are clarified at the legal level, and which draws not only the past practical experience of Chinese financial institutions, but also the mature system of international futures trading. Although FDL does not use the expression that CCP is the buyer's seller or the seller's and the seller's buyer, I think the legislation is intended to be consistent. In particular, I would like to further elaborate that in Chapter 3 of FDL, clearing includes multiple levels, and namely the clearing of the CCP to the clearing participant, and also the clearing by the clearing participant to the clients. So in the process of futures trading, the agency model is adopted in, I would say, in Chinese market. Therefore, the finality of the clearing includes the finality of the clearing by the clearing participant, the broker, to the end user, to the client. So I think by leveraging the CCP model and the agency model, this will reduce the cost of the international clients, and I think this will help to develop and accurate. A lot of international clients may get involved and to expand the involvement in China.
Yes, we hope so as well. Thank you. Also regarding CCP, being recognized as a CCP in FDL, would Chinese exchanges also be recognized as QCCP by overseas regulators? How would FDL help the international business of domestic exchanges? Yin, would you like to answer that?
Sure. Recognition as a CCP by the FDL, together with the protection of settlement finality and close-out netting, would no doubt give market participants greater confidence in the Chinese exchanges. This would also further promote and demonstrate Chinese exchanges compliance of the PFMI standards as issued by CPMI and IOSCO, and hence help them to be recognized as QCCP by overseas regulators. That being said, different jurisdictions do have different procedures for recognizing overseas QCCPs. For instance, in order to be recognized under EU law, China needs to be recognized by the European Commission as an equivalent jurisdiction first, and the relevant exchange needs to obtain recognition from ESMA as a third country CCP. And for US banks, for example, such formal recognition from local regulators might not be required, and a US bank will need to carry out its own independent assessment based on the applicable rules. So we do note that the European Commission has announced earlier on in June this year that regulatory framework of the CCPs regulated by PBOC as equivalent to EU. And no doubt this is closely related to the publication of the FDL. So although this recognition only applies to CCPs regulated by PBOC at this stage, by given the similarity of the regulatory framework, it should be much easier going on for CCPs regulated by CSRC to obtain such recognition as well. So apart from compliance with the PFMI standards, in order to get the QCCP recognition, there are also other considerations in overseas jurisdictions as well. So for example, they might look at whether there are relevant MOUs in place between the relevant jurisdictions, and maybe there are also requirements for mutuality of the treatment between these two jurisdictions as well. So but given the legal certainties granted by the FDL, I think the market participants do have a greater confidence that the recognition in overseas is just a matter of time. And what if Chinese CCPs do obtain QCCP recognition in the overseas jurisdiction? First of all, no doubt it gives people more confidence on the safety and stability, and it also could substantially reduce the regulatory capital that investors from such a jurisdiction need to set aside and make their trades much cheaper than before. So hence, this will give overseas investors much more incentive to come and trade in the China futures market. But that being said, one related point is that in the case of client clearing through an onshore clearing participant, even if the relevant China CCP has been recognized as a QCCP, in order to get favorable regulatory capital treatment, the offshore investors also need to assess whether China's client clearing model is principal model or agency model, and evaluate their right of close-out netting against the relevant clearing member in the case that they determine this is principal model. But as we talked about earlier on, it probably is more akin to agency model. But yeah, there are also additional factors need to consider in the event of client clearing. Thank you.
Okay, thank you, Ying. And if we look forward, Stanley, what do you expect the FDL will have on futures and derivatives market going forward? Anything that the audience shall watch out for in the future?
Thank you, Yiping. Well, I think this is a big question, and many of our panelists here have shared their insights. And to me, I think, for legal professions, we still have a lot of work to do. I think after the law has been published, we will need to amend, and I think they have also amended the futures trading regulation, and the CSRC is going to draft and publish more and more detailed implementary rules, and also I think the exchanges will amend and publish more trading rules to support and the development of the market and the introduction of the new law. And so I think the market players will need to pay close attention and keep a close eye on the development of the new rules. For example, I think for the cross-out netting and single agreement, the law said that the master agreement will need to be filed with the government agency, but we still do not have the detailed rules of this filing requirements. Who will be the filing entity, and what will be the procedure for the filing, etc. A lot of detailed rules will need to be drafted and published in the next, I think, maybe 1 or 2 years. And for the participants, as I said before, along with the development of the market, there will be more and more participants entering into this market, both domestic and international. And also there will be, I think there will be more and more types of contracts and products, and also transaction structures. This will also give rise to more and more risk, both transaction risks, performance risks, and also compliance risks. So as a lawyer, I think my suggestion to the participants is like, with your expansion of your business, watch out the risk, and I think that will make all the participants more comfortable, and also the more healthy of the whole market. Thank you.
Okay, thank you, Stanley. Attilio, what's your opinion? Do you see any other possible regulatory developments or improvements there?
Thanks, Yiping. Look, just sticking with the FDL for a moment, I agree that the implementing regulations are going to be very important. Having regulations that provide clarity and certainty, particularly around areas that we've talked about previously, you know, that the cross-border marketing and licensing, and also the cross-border data transfer. I think that the regulations and guidance that's provided around those requirements, offshore investors and institutions are going to be watching that very carefully. But more broadly, you know, hopefully the FDL is really just a first step. It's obviously an important piece of legislation, but hopefully there's more to come in terms of, you know, further opening up and developing futures and derivatives and capital markets in China that are robust and efficient. You know, so hopefully beyond the FDL, we hope that policymakers and industry bodies in China, continue to promote, the awareness and the benefits of using, futures contracts and derivative products and other financial instruments, for risk management and liquidity purposes, and that support is given to market participants and investors, helping them develop the right sort of risk management systems and compliance frameworks so that they can manage those transactions more effectively. So just one example would be, which I think Kimmy mentioned early on, which is the development of margin rules and a framework for margin and capital rules. That's an example of where we might head next. Thank you.
Okay, thank you, Attilio. I think the good moments always fly fast. And thank you so much for the time by sharing your experience and opinions, my panelists. And thanks to the audience for your patience as well. So much for the panel discussion today. And now I would like to pass the mic to my colleague.
Okay, thanks, Yiping, and all the panelists for sharing your views on the FDL from so many different perspectives. For those of you who are located in Shanghai, you might have noticed that from the beginning of this seminar, it's been raining very heavily. It's good to see that the temperature is finally cooling down after hitting over 40 degrees Celsius for days this month. But we expect that the heated discussion on the FDL will continue, just like what we did just now. And we also hope that today's discussions on the FDL can leave our audience with many inspiring points or takeaways regarding the Chinese futures market. And again, thank you very much for all the guest speakers and also for the audience for joining us in this webinar. And before we put an end to today's webinar, you can see a QR code on the screen in the middle of the screen, which is INE's mailing list. If you want to receive information on future INE investor education events, newsletters, statistics, etc., please fill in this form and register to the mailing list. That's all for today. Thank you.
Thank you. Bye.
Thank you.